Hi, I'm a representative of Olegs Roscins in his investment arbitration case against Lithuania. The case is quite easy. In fact, the Lithuanian government has expropriated $14 million from the accounts of the Russian companies merely on the basis of the fact that those companies were incorporated in the BVI and Nevis. There are no criminal claims from Lithuania. There are no tax claims from the Lithuanian government. The only thing is that those companies were incorporated in BVI and in Nevis. And this is a ground, according to the Lithuanian government, to expropriate the money, to take all the property into the possession of the Lithuanian authorities. This sounds shocking for the business community, but this is how countries like Lithuania work. It is a very corrupt country, the most corrupt one in the European Union, with a corruption level much higher than in Russia or Latin America. So, and by the way, there are no criminal charges, not only in respect of Russians, but also in respect of former shareholders of his companies. None is convicted. The hands are absolutely clean. The defense of the Lithuanian government is limited to two arguments. First, they say that the intra-EU bilateral investment treaties are not valid, that they are renounced from the day when a particular country joins the European Union. In this case, Lithuania is a part of the European Union, unfortunately, and Olegs Roscins is a Latvian national, so Latvia is also a part of the European Union. So, the Lithuanian government says that the bilateral investment treaty between Lithuania and Latvia is not valid because both countries have joined the European Union. We have already over 20 awards by investment arbitration tribunals dismissing this kind of argument. This is not a valid way to renounce to your obligations under bilateral investment treaties. So there are already over 20 cases where this argument is dismissed. This is why I am absolutely sure that it has no chances of success. And the second argument of the Lithuanian government is that Russians became the owner of those companies during the expropriation proceedings. Well, yes, he became the owner during the proceedings, but before their end. So at the moment when the expropriation proceedings on the basis of incorporation in the BVI and Nevis were terminated, at that point he was already the owner of that money. This is not a valid argument. This is not an argument that has chances. Both the Lithuanian Civil Code and the Latvian Civil Code provide that illegally detained money should be compensated with the compound interest of 6%. In other words, currently we do not talk about 14 million. We talk already about 32 million euro under the compound interest of 6% in the possession of the Lithuanian government that we can take back by continuing the arbitration case with the ICSID. Unfortunately, the arbitration proceedings are quite expensive. Therefore, Mr. Roscins currently looks for two options. He looks for an investment of 2 million euro to continue the proceedings, or he could also sell his case. If you are interested in one of those two options, just write me an email or call me on WhatsApp.